session will be posted in the chat box of valedictory program. Kindly cooperate. And on this day, it's my honor to welcome our chief patrons, Dr. Chainraj Roychan, Chairman, Jain Group of Institution, Shri Ravindra Bhandari, Vice President, Jain Group of Institution, patrons, Dr. Sundar Rajan N, Pro-Chancellor, Jain Deemed to be University, Dr. Ishwaran Iyer, Pro-Vice Chancellor, Jain Deemed to be University, Mr. Hemant Kumar, Executive Secretary and Chief Scientific Officer. I also welcome our mentor, Dr. Navid Kumar CM, Principal, Jain College. I extend a warm welcome to all our participants and my dear colleagues who have been enthusiastically taking part in this FTP. I deem it as my honor to welcome today's resource person, Ms. Brinda K. Verma. Ma'am holds a Master in Biochemistry and Biotechnology, an LLB degree from Bangalore University. She also holds a post-graduation degree in Business Administration from Symbiosis. She is a registered Indian patent agent and qualified to practice before the Indian Patent Office. She is the recipient of Association of Overseas Technical Scholarship for Patent Experts. Ma'am has over 14 years of experience in dealing with IPRs, including patents and trademarks. She is also the managing partner of Acom Legal, and she was involved in handling several research-based collaboration with industries. She worked towards pursuing a systematic, mutually beneficial engagement with research-based national and international companies. We welcome you, ma'am. I now request ma'am to take over.
Thank you. Before I start, I thank the Jain College, the entire Jain College group and KSCST for giving me this opportunity. And I think before that, I should apologize that I logged in late. The reason is today, suddenly there were a few court proceedings and I was forced to attend that I just couldn't let go. So, but I'm happy that at least I managed it on time.
No, just 5 minutes. Okay, it's fine.
I'm sorry about it. So, and I really should congratulate Jain College even during this tough times. You know, you've been arranging such wonderful sessions. And yeah, the topic today, I'm going to talk to you all about is challenges and opportunities from the global perspective pertaining to the intellectual property rights. So in the next 1 hour or so, I'll be covering the following aspects. And I think it's always nice to let everybody understand the concepts of IPR and what's happening internationally and what are the international regimes available to one, to really exploit the IPR through case studies. I've actually collated not couple of them, at least I think 4 or 5 case studies so that I can make you understand how the IPR should be used for the benefit of your intellectual growth, or I would say even for your companies, if at all one plans to have your own entity or even working for an entity, whichever it is, whether it is a university or if you're working for a private entity or private limited company, doesn't matter. So how one can actually use innovation and IP for the benefit of your organization, but for the benefit of the country at large is what is important. And that's what I'm trying to cover through the case studies. So the next, these are the primary aspects which I'll be covering. So growth of innovation and IP. So trying to tell you how important it is. Then international IP regimes. I'm just trying to give you an overview on that. Importance of IP rights for exporters, because that is where your entire international trade would all be applied to. Then freedom to operate, which is also very important. Protection and freedom to operate, I will also let you know through the case studies, and protection of IP rights in export market. And I would also be giving you some of the statistics, to let you know where the world stands. I will not be focusing only on the Indian perspective, but I will let you know where we stand pertaining to the different IPR filings across the globe. So with regard to the growth of innovation in IP, I think by now, based on the various sessions, all of you would have understood or even appreciated the importance of intellectual property. Innovation definitely represents the creation of new value for the world, right? So, whether you're coming up with an altogether new invention, or you're trying to develop over the existing inventions or existing technology, there is some value which it adds to the world. And the value may be automatic. So maybe once there's an improvement, people try to understand, okay, these are the add-ons which I probably am expecting with regard to the technologies, or probably this technology over a period of time is forced on to the world, and without that, maybe people cannot, they can't go ahead without that particular technology. I think some examples like that are washing machines. And earlier, I think everybody were happy without a washing machine, but now washing machine has become so integral, to every household. It is very important for us to have a washing machine. Though probably without washing machine, we can still wash our clothes, but still the technology is so important that, we feel that, or maybe, it eases our lives. So that is where innovation adds a lot of value to the world. So whether it is created through new technologies, new business models, as I said, new products or services, or it forms part of any social and entrepreneurship, doesn't matter, but it definitely adds a lot of value to the world. And there is no doubt that there are a lot of research studies which shows that IP plays a key role in driving innovation and economic growth. Now, how does it do? I think all of you definitely agree with me that IP is everywhere. Whether you have protected it in the form of a right or not depends on what, as an individual, you are actually expecting out of your creation, what as an entity you're expecting out of that creation. But intellectual property definitely is there everywhere you think of. Whether you're drinking a bottle of water, you have IP in that, with the name of the product, name of the company of that water, the way the bottle is designed, the way the label is being designed. So there's intellectual property in it. So you do not find the same color combination of what Bisleri has with Kenley, right? The Kenley color combination is different from what Bisleri has. The content, the way it is written is completely different. So that is all intellectual property. Now, how one leverages it, how one really utilizes it for the benefit of the entity, it all depends on how important you feel that intellectual property is. There is also no doubt that intellectual property, would really give you a better advantage when it comes to competitiveness. Particularly when they're technology-oriented companies, right? Now, if you do not have a constant innovation, automatically over a period of time, you tend to fall down because you are not able to survive the competition pertaining to how your company is growing related to the technologies you are in, right? We have seen companies collapsing either for, not managing the company, or probably because they could not foresee the requirements of people, way ahead than their competitors. So Sun Networks, for example, it was doing fantastic, but then over a period of time, it collapsed. So that is how you try to compete in the market. Nokia, it was doing very well, in those initial basic for mobile phones, but then later, it really could not catch up to the requirements or the way the competitors were really progressing in that particular technology. And of course, various other reasons, it had to come down. The market share really came down. And, you have other companies like Samsung or something just picking it up. So that is where innovation really matters. So it is not that IP, is restricted only to a few things. The more development you have and the more ideas you have to think, and the importance, you realize the importance of IP for any entity, that is where you grow. Now, how does it really help the international trade? So the minute we talk about trade, so in layman's language, something I'm going to sell internationally, right? So exchange of goods probably, or the way I'm going to place myself in an international market, the products I'm going to sell internationally. Now, for a person to do that, for a company to do that, how easy is it? So can I just go across the borders and start selling my products. Are there any issues? Of course, one is the legal issues, whether that country is going to permit you is one. Secondly, even if that country permits you to sell that product, what kind of a product are you selling? Is there anybody else selling a similar product in the market which you are trying to sell? And if there is anybody else selling that product in that particular market, are you trying to infringe that product, or is somebody else trying to infringe your product which you intend to put out in that market there? Now, these are various questions which really come up, right? If you are just anybody who's entering into international market, even the local market, for instance, you would not be selling a product or selling a service or providing a service without any name associated with it. Let's start from the trademark itself. Without the name, you do not provide any services, neither you give any product, right? Now I'm going to go place my select, because I took up the example of a water bottle, let me just take the same water bottle. Considering that Bisleri is mine, okay? So imagine now I'm going beyond India, trying to sell my Bisleri. So I'm going to place my Bisleri bottle in a country like Sri Lanka, for instance. So what is that I'll have to do first? Can I just go ahead and place my bottle there? What kind of intellectual property protection do I have there? Now, is there a possibility that somebody else can start selling that water bottle with the same name? I think by now you've already analyzed how the trademarks are protected. How easy is it for me to go and protect my trademark in those countries, in the countries which I want to export, for instance? What is it I actually have to see in this international trade? Are the policies, are the treaties, international treaties supporting me, supporting citizens which are outside the country, non-citizens of that particular country? So are there anything governing me, or is there still a problem with regard to enforcement? Once I place my Bisleri and somebody tries to copy, because I am not a citizen of that country, if somebody tries to copy that, what kind of privileges I have? What kind of rights I have to enforce? Now, if the laws do not support you with regard to that particular aspect, do you think you really can go ahead and sell that product? No. So that is where the entire gambit of your intellectual property from the international perspective with regard to, you trading internationally really comes into picture. And there's a lot of thought process which has been going on for quite, for the past, I would say, 2 centuries. And of course, this international trade is, I think, going on from time immemorial. So it is not that it just started recently. It is there. But then slowly, there were different perspectives, different kind of technologies which have come into market. But under this, particularly, the World Wide Web, which is just open, and the way everything is being turned towards the online mode of selling products, providing services. Considering all these things, where do we stand? And over a period of time, how has there been a progress with regard to the intellectual property regimes? What are the various aspects which have been considered? What kind of support is provided to every country who's a signatory there? So these are some of the aspects which were being well thought. And of course, all these, there are several policies which are also being framed internationally to address various upcoming issues based on how the world is changing. And it is also focused on various industries. Okay, it is not that one policy fits every industry. No, it doesn't work like that. So it's trying to focus the requirements for every industry, and every industry also based on the kind of products they're coming up with, say whether it is pharma or whether it is the IT industry or the semiconductor industry. So each of these industries will have to understand how they will have to go ahead and place their products in international market. And what are the kind of different protections and different systems available for them so that they can compete well, and they can also exploit their products without the fear of losing any right in a country where they're not citizens. I think my slide is not moving. Yeah. So in order to address that, I think TRIPS, one of the international regimes, because you should have some kind of international organization governing the entire intellectual property rights of yours. Right? So likewise, we have two, I always say there are two important international organization. While one is the trade-related intellectual property aspects, and second is the World Intellectual Property Organization. So TRIPS comes under the WTO, the World Trade Organization, which is one of the best agreements available on all the issues of intellectual property rights available to you. Okay, and this TRIPS is the one which actually recognizes the rules and certain guidelines which should be made applicable by all the signatories. Okay, whether it is protection or whether it is enforcement or whether it is prosecution of that particular thing, every signatory will have to follow the TRIPS mandate. It is very important that they have to follow the TRIPS mandate. I will also give you a few examples of how relevant this TRIPS agreement is for all the countries. Now, if they don't, what are the kind of consequences that they may face? So the entire thing, began with the Paris Convention on the Protection of Industrial Property, which was concluded in 1883. And this was the first instrument to cover patents on industrial innovations. Followed by the Berne Convention. Paris Convention, as you can see, was basically on patents and industrial innovations. And then came the Berne Convention, which recognized, the copyright-related aspects. Then came the Madrid Agreement. So Madrid Agreement, it recognized the international registration of trademarks, of all your marks. So what under this Madrid, so basically what happens is if there is anybody who wishes to go ahead and file for a trademark in several countries, so Madrid Agreement gives you that option. It is not that, if you're from India, that you file in India and you can go ahead and use this trademark across all the countries. I think, protection is jurisdiction based. So that is the reason why they had to come up with different agreements where protection can be given to you across several countries once you file for such kind of a application. There was also something called United International Bureau for the Protection of Intellectual Property. And this was an umbrella organization which basically was trying to address several intellectual property related aspects. And that eventually turned out to be evolved into World Intellectual Property Organization. So that is what we call VIPU. And now everything is administered by VIPU. So this is an international body which deals with the complete regulation of intellectual property rights. So it, of course, became a formal part of the United Nations in 1974. So any kind of new agreements you have for various intellectual property rights, whether I spoke about the Madrid Agreement or the Hague Agreement, all these things become, is all administered by WIPO. So that's the only reason I said there are two international aspects which we need to consider here. One is WIPO, which is an international body which governs everything. And then comes your TRIPS agreement, which basically covers the complete intellectual property related aspects as to how every country should, as I told you, protect, prosecute, and enforce the intellectual property rights. So that is where the primary difference lies. I was also trying to, the previous slide, I told you how important is the TRIPS agreement. And I was trying to, I was just telling you that I will give you a couple of examples. Now, assuming that one of the countries, say India, is not part of the TRIPS agreement, then what would have happened? Say I was, say I would want to go ahead and file for a patent in US, okay? If I was not a signatory to this TRIPS agreement, how is that US would treat me basically? Now, as per the TRIPS agreement, it says that every applicant who files for a patent outside their own country, for the purpose of grant of patent, they will have to be treated as a citizen of that particular country. So, which means to say they will have to be treated equally, right? They cannot be given any kind of different privileges, or there cannot be any differentiation. They'll have to treat me just the way they've been treating their citizen with regard to the grant of patent. Now, what happens here? As you all know, the life of a patent is 20 years, right? And the priority also starts from the day you file for a patent in your first country, in a convention, whichever country you file. So if I have filed in India first, I can use the same application and file it in US. Now, if I'm not a signatory, what happens? Will they consider my priority application, say, is not considered? Then if I go ahead and file it there, okay, if my priority application is not considered, if I've been treated as a fresh applicant, obviously a patent would not be granted, because tomorrow, when you try to do your prior art analysis, okay, your first application, which is filed in India, would become your own prior art, okay, and based on that prior art, you would basically lose rights, okay? So there is no equality there, and that is the only reason the minute you become a signatory to this agreement, so your priority date will start from your first application in whichever country you have filed, does not matter. That is a uniformity which they will have to give you. Second thing is the 20 years. Wherever you file, from the day you have filed, your term starts. 20 years would start from there. That is also uniformly applied across. Now, the other uniformly regulation which has been applied is with regard to the publication of your patent. So upon the completion of 18 months, okay, your patent application will be published. Compulsorily, it has to be published. So this is the same across the globe. Now, what kind of inventions are patentable? This is also clearly mentioned in TRIPS. So based on that, you are supposed to grant patents in that area. That is why even India because it's one of the signatories, in 2015, it had to amend its own laws to ensure product patent is granted to its pharmaceutical industries. Earlier, product patent was not provided to product patent was not provided to pharmaceutical products. So based on this, it was forced to do it, and it has amended its own patent law to ensure product patent is granted to pharma related inventions. So every country has to be streamlined and ensure that patents are granted to certain inventions which has been provided under that particular agreement. So that is how it is important for a country to become a signatory. Sorry, there was a okay. Now, importance of IPR for exporters and importers. Okay, so I think I'll just focus on the export plan here. So when anybody thinks of exporting a particular intellectual property, they have a particular product or a design which they have, which they would want to go ahead and export. What is that they do? They go ahead and identify appropriate markets. That's the first thing you do. You decide which market you will have to go. Then you go ahead and estimate the demand and market requirements. Then you identify the local partners and channel of distribution, right? That is very important, because you cannot go and establish yourself from the day one without having some kind of a backup from that particular country, because you're yet not a localite there, or you've yet not established yourself there. So you try to, that is how everybody tries to export first. They try to find the local partners, and channels of distribution is identified. Then what you do, you try to adapt the product or its design, the brand, or your packaging to the new market. So that's another thing which you do. Probably not all products, but yes, some of them are definitely. Even let's take an example of phone. So an Apple phone which is sold, or a Samsung phone which is sold in China, gives preferences to the Chinese language. or Korea to the Korean language, right? So you have, or in India to some of our Indian languages. So they try to customize it to suit the requirements of that particular country. So that is how it is changed. So negotiating and signing contractual agreements with export sale representatives, distributors, local partners, local manufacturers or licensees, etc. So when you're trying to sell your product and when you're trying to interact with various local partners, manufacturers, right? It is very obvious that you would be signing a lot of contractual agreements with them. To ensure that your rights are well protected and also you receive your payments well in time. So that is another thing which you'll always have to keep in mind. And that's a precise reason why you go ahead and sign suitable agreements. Then you also try to determine prices for different export markets. So mineral water bottle, what I sell in India probably will have a different price when I sell it in US or when I sell it in Sri Lanka or when I sell it in Japan. So it'll have different prices, maybe because of the different designing I'm using or the way I'm branding it out there, the amount I'm spending there. The other aspect is budgeting export operation and raising funds. Okay, so this is another thing which you'll keep in mind when you're following any particular plan for you to export, right? Then the idea of marketing, transport arrangement for exports. Okay, so all your whatever transport arrangements you'll have to make for exporting the product from India to that also will be considered. Advertising, marketing the product in the export markets. Okay, participating in trade shows or other events abroad. Now, these are some of the aspects which you would definitely include in your export plan. Without this, you would not be going ahead and just marketing your product or placing your product in a different country. Now, under all these things, let's see where does your IPR fit in. Okay. First thing, when you're trying to identify appropriate export market, I give you an example there. So, I took an example of Bisleri. So if I'm going to take Bisleri and sell it in another country outside India, if I consider Sri Lanka to be the next target, my export market, I'm trying to place my product there in that particular market, which I've identified. So what do? I estimate my demand and market needs. Then I try to find the local partners, right, and channel of distribution and go ahead and do it. I also adapt the product, its design, its the brand or packaging. Now, for example, if the trademark laws of Sri Lanka does not permit, or they feel that the name Bisleri is offensive to them, okay, or maybe if I add an image of Gautam Buddha on that bottle, and probably something like that is very offensive to country like Sri Lanka, what I have to do, I'll have to make that modification. I'll have to understand what are the local laws there, right? To first and foremost try to see whether that trademark of mine is in any way against the trademark laws of that particular country. So that is where I will have to ensure I do my due diligence before entering into that market. Now, if I don't do that, you will only end up in either being sued or, trying to be, probably penalties will be applied on you for not understanding the local laws and bringing the product or selling the product in that particular country. So one needs to be very, very careful there. When you're trying to negotiate any contractual agreement, the minute your brand is very strong, okay, the minute your product is very strong, you have a patent, a particular brand, say I have a patent, and the trademark is also well established. So your contractual agreements also would be that strong, right? Because you have a dominant position there. You are going to dominate in the negotiations. You will decide what is the kind of price or what is the percentage you will need when you're trying to sign on any of these contractual agreements. You will decide what is going to happen if that particular manufacturer in that country is going to make any modifications. You are the one who's going to determine whether any improvements to that particular product will belong to you completely, or you would be sharing the rights with that local manufacturer. So it all depends whether you have that kind of protection or not. Now, if you do not have an innovative product, what is the kind of innovation you're bringing in? What is the new thing you're bringing in your particular product? Is the packaging, is somebody focusing on the packaging, or the quality of a product which is much better than the other products where you're trying to launch, and connected with your trademark, which, the image which you have built over a period of time, the value which you have built over a period of time. These are the various aspects which should be considered when you're trying to export, and brought in very, very clearly in all your contractual agreements. And when it comes to pricing, the minute you have a strong protection, the minute you know that you're already doing well in India, probably you'll take the same image outside India because you have strong intellectual property rights protected, in your name. You play it around, you just go and play with that, right? You say, okay, this is my IP rights, and I'm going to decide on the price which you are going to sell the product in that particular market. So everywhere, the minute you have some kind of an IP protection, the value of that product, the value of the services which you provide goes up, right? When you compare to the companies where they don't have the appropriate intellectual property rights protection. So I try to explain this more with some of the case studies here. So this is pertaining to a prior registration of a trademark. Let's see what is this case all about. So a European electronics producer with an internationally recognized brand for personal computers. Okay, so it was called as BHT. So they were interested in setting up a business in Southeast Asia. Now, upon carrying out their initial research into one of the Asian markets, they discovered that there was already a prior registration for the brand, okay, and it existed in that market. So having been submitted by a local party 5 years before. So a local party has used their own brand and went ahead and sought a brand protection, okay, and they have also got a registration for that particular brand 5 years prior to them entering into the market. Now, what did that registration cover? I'm assuming that all of you know how trademark works. So the local registration covered stereo systems and electronic radios. Okay, now this particular European company was advised by a local attorney that the trademark registration by the local party basically would block any application put forward by the European company, right? Because there's already a prior trademark application which has been filed and it's been registered. So considering that, obviously you have the first to file system. So I have gone ahead and already filed. So there was no objection raised by this European company. So obviously the local company had an advantage and they have got this name. So what happened here? The European company, however, went ahead and applied for a trademark registration. And simultaneously, they started investigating into the activities of what the local company was doing, the one which had already registered prior to the European company. So they found that the local company was not actually using the mark. Now, since the trademark related thing has already been covered, all of you must be knowing that in case you have not been using the registered mark for several years, there is a possibility of the trademark office cancelling that mark. So the European company, they went ahead and tried to cancel that registration, which was allotted to that local company, owing to the lack of use of that particular trademark. Okay, so that is what they did. They filed for it. Although the cancelling of the earlier trademark was expensive, okay, the reason is because they had to put a lot of investment into the market survey and also tried to defend the local company, okay, for cancellation, because it is just not that as soon as you apply for cancellation, the trademark office will consider it. So there will be a hearing, and the other company also will have to come forward and handle the hearing. An appeal was subsequently submitted to a higher court despite the fact that the European company had already succeeded in the initial hearing. Okay, this is what has come. However, yes, the European court ultimately, the European company ultimately succeeded. They were able to, register their trademark by cancelling the trademark registered by the earlier company. But what are the lessons one learns under this? If you have any idea of, trying to enter into some of the markets, if you anticipate that, okay, you would probably grow, see if you can get a trademark in those countries, because trademark is not a very expensive affair. You can always utilize international agreements for protecting trademarks in multiple countries at the same time. Try to utilize that, and it can really benefit you. And then please use the local investigator to ensure that you acquire that mark the way this particular company did. They did their due diligence well. Perform trademark searches before you decide to apply for trademark protection. Otherwise, you may later encounter a prior registration that conflicts your trademark the way this company encountered. Once you obtain trademark protection, use it for the classes in which you receive protection. Otherwise, you risk cancellation due to lack of use. Okay, so this is how the local company lost, because they hadn't used it already, although they're protected in that particular class, which the European company did protect. So whether you're from the European company side or from your local company side, you'll have to clearly learn what is that you need from this particular trademark registration. Let's go to another case study. This was related to a patent dispute. Now here, a British pharmaceutical manufacturer who was a leader, or who is a leader in the production, of an anti-cancer drug. Now he was exporting to every major developed country for the last 20 years, this particular drug. And also, he started doing it, exporting that to developing countries, particularly in Southeast Asia. Now, let's try to understand what he was doing here, right? So, anti-cancer drug, and he was exporting already to major developed countries. Now, what is that he needs to do? First, try to see in which country he needs protection based on his market analysis, right? So when we're talking about an international regime, he should go ahead and seek patent protection there, because he's exporting his anti-cancer drug, which he would have got a patent in his country, right? Based on that, he's exporting. Now, if he has to export without any competition, he should have gone ahead and filed for a patent application in the countries where he intends to export. Now, if that doesn't happen, obviously, even if he exports, as for the patent law, as you all know, that there can be another competitor who can go ahead and manufacture the same drug without seeking his permission, because he doesn't have a right there, okay, to stop that person, the local manufacturer, from producing and selling it. So one needs to be very, very clear. Only because you are a signatory to TRIPS, you have that privilege of going ahead and seeking protection in multiple countries at the same time, through something called a patent cooperation treaty route. So if one files a PCT application, that's an advantage of being a signatory to international treaties. That is where World Intellectual Property Organization is trying to help all the exporters, all the people for in trading internationally, to ensure that you have a common system for filing a patent application. You don't have to go and struggle understand the local laws of every country for you to file for a patent. Even trademark, you don't have to understand the local laws for filing a trademark in each country. So this is where it's trying to bridge the gaps or the lacunas one has to understand the local laws. And instead they say, you don't worry about the local laws. This is a system which we have in place to help in the international trade. So you have a Madrid system, you have a PCT, go ahead and file a patent in case you want to explore the multiple countries. Use this route, and then there's just one guideline which needs to be followed. Then for designs, if it is an industrial design also you have a similar right. So once, you have Hague system, which can actually help you file industrial design in multiple countries at the same time, even for copyright. Copyright law, also clearly tells you if you publish it in one particular country, it will be considered that you are the author or you are the owner of that particular work across the globe. So this is all happening only because you have the appropriate international treaties, international agreements in place to help you go ahead and focus on your business and not to worry about too much about losing rights for your innovation. So this British company, coming back to this case study, so this pharmaceutical manufacturer, they had this active ingredient which was patented, okay, but the original patent expired 3 years ago. However, a new improved process for making the drug was patented 10 years ago. And this patent is still in force in various countries, including Singapore, Malaysia, and Indonesia. So what does it say? The active ingredient of the drug was patented, but the original patent expired 3 years ago. However, a new improved process for making the drug was patented 10 years ago. And this patent is still in force in various countries, including Singapore, Malaysia, and Indonesia. Now, 2 years ago, the manufacturer found out that a generic manufacturer based on Vietnam was making and exporting the anti-cancer drug to Malaysia, right? So the manufacturer found out that a generic manufacturer based in Vietnam was making and exporting the anti-cancer drug to Malaysia and being sold in these countries for half the price of their own drug. This was having a serious adverse effect on sales. Now, I would want each one of you to analyze this and put out your response in the chat box and tell me whether it was right on the Vietnam generic manufacturer to go ahead and do that. Would it be considered to a patent? Would it be considered a patent infringement? Or would it not be considered to be a patent infringement? Okay, that is what we need to understand from this case here. So can you all just open your chat box and provide me your answer to this? I think in case you haven't understood the question, you can read this.
Ma'am, 2 minutes, they're just sharing the answer.
Okay.
So they're answering, yes, this is a patent infringement.
Okay, I can't see the response. Is it
Vandana?
because... Yeah, I can hear you, but I can't see the response of the chat. Is something missing from my end?
Yes, ma'am. Ma'am, they're saying, yes, this is a patent infringement.
Oh, they all feel it's patent infringement, and somebody says...
Yeah, and Usha ma'am has replied as patent is invalid.
Okay. Let's try
Patent
to
is
understand.
invalid.
Let's try to understand this again. Somebody is saying patent is invalid. Not very sure why you think it is. So when you say invalid, does it mean that, the Vietnam company can go ahead and market and export? Is it because of that? Okay, I think there's another
Yes, ma'am. Ma'am, from Gaurav, they've said generic drug manufacturer has to prove the same bioavailability of the generic drug as that of the commercial one.
Okay, now let us try to read this paragraph again for a better understanding. And I'm reading this, I'm not getting into the patent details, assuming that all of you are already aware of what are the rights available to you as a patent holder, as an applicant. What are the kind of rights that are available to you? I'm not getting into that because there's already a session which is covered on patents, right? So I'm trying to tell you here, the active ingredient of the drug was patented, but the original patent expired 3 years ago. So I've already put that statement that it was expired 3 years ago. However, a new improved process for making the drug was patented 10 years ago. And I'm saying that this patent, which patent? The process patent is still in force in various countries, including Singapore, Malaysia, and Indonesia. Now, what is a Vietnam company doing? Vietnam company is going ahead and manufacturing the anti-cancer drug and exporting to Malaysia. Now, once a patent for a product is expired, do I have a right to manufacture? That is what the patent law says. It says, yes, once the product patent is expired, I've said it expired 3 years ago, which means to say me from Vietnam, I don't have to go and seek permission from this British pharma company to go ahead and manufacture that product. Okay. I can go ahead and manufacture the product and sell it to anybody I want to in any country of my choice where the British pharma does not have a right. Now, British pharma company does not have a right anywhere across the globe for this particular drug. But the British company had come up with a new process. So they only came up with a new process, but not with a product. So which means to say, this Vietnam company cannot use this process to manufacture that product, but however, they can use any process, okay, of their choice and manufacture this product because there is no patent for the product. There's only patent for a new improvement of the process. So Vietnam company is not infringing, okay, the product patent because it's already in public domain, and Vietnam company is also very smart. They're using a different process. They're not using the same process. So obviously, the British company cannot go ahead and sue the Vietnam company. So that is how one needs to analyze. Any right, only when you have that, it can be exploited. Now, if I don't have a right, what is that I'm trying to claim? Nothing. That's where I was trying to tell you, whichever country you go to, only when you have a right, you can enforce it. And only when you have a right, all these international treaties can come and help you. Now, if you have not gone ahead and filed for an appropriate application at the appropriate time, no international organization, none of the treaties can come to your help, right? So one needs to be really vigilant, exploit whatever is available to you, and then go ahead and enter into those international markets. So that is the objective of having these kind of, agreements, international agreements and treaties. So the advice given to this particular manufacturer was, the British manufacturer was informed that patents are national rights, right? So all of you know that it is jurisdiction based. So you will have to go ahead and protect in the country of your choice. And therefore, action could only be taken in the countries where a patent existed. So when the patent does not exist, nobody can stop. So in this case, the manufacturer had not registered any patents in Southeast Asia, in all of these countries again. There is no, again, common patent for Southeast Asia. They'll have to go to this individual country. So a patent for a product is infringed if a third party makes, imports, sells, offers to sell, stores, or uses a product without the permission of the patent owner, right? That is what it means. So once you don't have a patent, then one does not have to do any of these things. So the British manufacturer was advised to contact a local expert to determine the exact process steps being used by the generic manufacturer before engaging in litigation. So this was a warning given to the British manufacturer to basically understand what kind of a process is being used. And if that process patent is filed in Vietnam, okay, one needs to go and understand whether the same process is being used to produce the same product, to produce that product. Now, in case the same process is used, and if there's a patent filed in Vietnam, British manufacturer can engage themselves in the litigation. However, if they've not done it, then they lose the right. Okay. Okay, let's go to another interesting case here. So a European company selling advanced knitting machinery to manufacturers in China. So they basically discovered that a local competitor was selling a competing product not under the company's European trademark. So the dimensions, exterior covering, colors of the product was the same. Even the brochures, the website photos of the original product was copied by this local manufacturer. I think the minute we see, we hear the word China, it is very common that this kind of copying happens. So apart from this, even the product specifications of the original product were given this, even though the local product did not meet those specifications, right? So exact specifications of the European company was mentioned in that product, although it did not meet the meet the requirements provided by the original product. So as an obvious result of this, the customers were misled. However, the company did not have any patents registered in China. It could only rely on claims of copyright infringement. Okay, so one of the disadvantages here is they didn't file for any patent here. So what did the company do? They could only rely on claims of copyright infringement on their brochure artwork and infringement of an anti-unfair competition law in relation to the false claims on the brochure. Okay, so they engaged a local law firm to send a warning letter to the competitor, which led the competitor to change the photographs and some of the contents of the brochure because they were giving false promises. The company was left with no legal basis to force them to change the appearance of the product because they didn't have any kind of industrial design protection in that particular country. Therefore, we can clearly see that the importance of IP when it comes to a trade cannot be undermined. Okay, so if you think that you are going to go ahead and seek protection there, that's what I said. There are international treaties, please use them. Once you don't, if you don't seek any kind of protection, come what may, you cannot enforce it because that is what the law says. This is again an interesting case. I think I have another. I'll take another 10 minutes to complete. I have time till 5:15, so then I will open for Q&A for the and I think till at around 5:10.
Yes, ma'am. Sure, ma'am.
Okay. Sorry, I'm just missed the slide. I think. Okay, it should have been case study 4. Sorry about it. So here, the background is a Belgian entrepreneur set up a local food processing operation called VIPU in Indonesia. Now, one of their plant managers developed an innovation to the existing raw material cleaning process. The Belgian entrepreneur, believing that VIPU could commercialize this process by manufacturing equipment with this innovation, offered a reward sharing scheme and brought the plant manager to an attorney to discuss future contractual arrangements, as existing employment agreement was silent on ownership of IP in inventions. So this talks about several things. This talks about employer-employee relationship, the various contracts one needs to have, and how the Belgian entrepreneur and an employee either misused or benefited, which I'll tell you a little later. In the meantime, the plant manager secretly instructed a patent attorney to apply for a patent in his own name, right? A patent was not applied in the name of the company, VIPU, but rather it was applied in the name of the plant manager. The patent was drafted by a local attorney in the Indonesian language. I think all of you know that you can draft it in English or in your local language. Okay, even in India, you can draft it in Hindi as an official language. So as soon as the Belgian entrepreneur discovered the patent filing, he asked the plant manager to surrender the patent application to VIPU. Now, the plant manager refused. So what kind of an action can be taken? The court litigation ensured over rights to the patent application. Okay, so 12 months passed and the plant manager no longer had the funds to file an overseas application within the priority period. I think all of you know your 12 months or the 31 months, if you take up the PCT route, that this is a kind of priority is very important if you have to go into the international market. Okay, the right to file overseas was lost while the dispute dragged on. And why did this happen? Because one, they were trying to establish who has the rights, whether it is the employee or whether it is employer who has the rights. Why? Because the employment agreement wasn't clear enough. The court finally ordered that VIPU had a rightful claim to the patent application. However, the Belgian entrepreneur instructed his own attorney to review the patent application, who quickly realized the specification of the invention had been badly drafted. The risk now was that a third party could easily design around the patent to achieve the same idea behind the innovation. In other words, the specification was drafted too narrowly to effectively protect the innovative concept, and the rules regarding making amendments meant that the specification could not be improved at that point of time. So the Belgium entrepreneur was also informed that BE Food had lost the right to apply for patent protection overseas. Why? Because, one, he didn't have that sufficient money and he was still trying to establish who's going to own here. The grant of the patent locally in Indonesia would also take a long time, as examiners do not usually independently examine patents, instead rely on foreign patent grants in order to grant the corresponding local applications. In the meantime, the plant manager found an investor for an improved version of the earlier innovation. Now, this new investor advised him to have the patent specification prepared in English so that they could file it internationally. BE Food no longer had the resources to pursue the business opportunity behind the innovation. So first fault from the employer is not having appropriate agreements with their employees. So you do not know when your employee is actually going to come up with a fantastic innovation benefiting your company. Okay, so what are the lessons learned? Specify ownership of IP rights in employment contracts. Important to use trained and experienced patent attorneys so that your claims are well drafted, the scope is clear. Okay, although the standards can vary significantly, but at least you know. And particularly people in that particular country who have passed the examination of that local country's requirement. And give due consideration to filing overseas and drafting a patent application. So that is what one needs to keep in mind. And use the PCT so that you defer the application deadline by another 30 months. I think all of you know that under the PCT route, you get additional time to enter into the international market, right? So you defer the application deadline by another 30 months as opposed to 12 months. So this way you have the access of the commercial, access to the commercial viability. I mean, you can assess the commercial viability and also access the international market based on your assessment. So this is what the lessons one will learn, analyzing this case. This is also another interesting one. This is infringement of BMW's domain name in Vietnam. Now, BMW has encountered numerous cyber squatters and registrants acting in bad faith. See, one, of course, they can't manufacture a car similar to BMW because of the cost. So that's an advantage which the BMW has. But they have been facing a lot of the cyber squatters using the same domain name. So seeking to take advantage of the globally famous name BMW by integrating it into their domain name. So BMW actively maintains control of its brand online. BMW found that the domain names bmw.com.vn, okay, BMW Motorrad, BMW, hyphen Motorrad.vn. These were all registered by various cyber squatters. Now, the defendant argued that BMW in his domain name was not related to BMW as such, the per se trademark, but it claimed that it stood for Be My Wife. Okay, so that was the argument which the defendant actually took it up when he was questioned. And he also claimed that he had no intention of making money from registering and using the domain names. Cyber squatters, that's their objective. So they go and register the well-known trademarks as domain names, and then they sell that at a huge price to these companies. Now, BMW did approach the local government, and several of their domain names were taken down, although they didn't agree, but it was forcefully taken down by the ministry itself. Okay, and then for the remaining, they went to the court, and BMW did demand the surrender of the disputed domain names, compensation for damages of the Vietnamese dollars of 500 million, the recovery of legal fees, and a public apology in the mass media. So BMW won with regard to claims 1, 3, and 4. So they couldn't get the compensation for damages. The reason is they could not actually prove the damages which BMW faced because of the use of the domain name. And because they could not prove that, that was not allowed, but every other thing was provided. Now, what one needs to learn here is, when it is a very, very popular name, like Tata, your BMW, Apple, even though they don't have this, I'm talking about trademark registration, right? We are focusing here on trademark, but not patents. Trademark registration in all the countries in the world. Okay, and somebody tries to go ahead and use the same trademark or has this kind of a domain name, they can always be pulled down. They can always be sued for that, because they're all considered to be well-known trademarks. Okay, now even Tata, for example, it's a well-known trademark. So nobody in India, even if Tata is not probably in the manufacturing of, say, stationery, I'm assuming they're not. So if they're not in the manufacturing of stationery, and tomorrow I'm interested to get into that, and I will use Tata's name and start and come up with a stationery shop. Now, can I do that? What will happen if I do that? Of course I can do it, but what will happen if I do that? People will start thinking that the stationery shop is also opened by Tata. So you are actually benefiting by the brand which is already established, okay, and making money out of it. Now that is wrong, right? You cannot use somebody else's trademark for your benefit. So that is why for all the popular trademarks, you cannot go ahead and use them, although it is not being registered officially across all the countries. Trademark law, if although the session has taken place, that is why we say for trademark, registration is not compulsory. The minute you start using it, you automatically get a right for it. This is a precise reason. So because you've been using that in other countries, okay, you automatically get a right. But your popularity should be there. Everybody should have been recognized. I gave you a first example of BHT. Probably you might be thinking it's contradicting. No. Now BHT there, the first example which I gave, their trademark was not popular. Because it was not popular, the person using the trademark in that local country was not aware of it. So he also went ahead and used it. So there's nothing wrong in it. But popular trademarks like BMW, like Tata, like Apple, like Samsung, where where these products are there across the globe and everybody is aware of it, they can't use this. So that's why we use the word popular or well-known marks in the word. Okay, now this is the last case study here. Now, Textra Automotive is a medium-sized European company known for producing high-tech sensor for cars. After an extensive market study, Textra has decided to enter the Asian market. It identifies CM Manufacturing Group, okay, as a promising partner in Thailand and enters into an agreement with the latter to manufacture and distribute sensors to vehicle manufacturers in Thailand. So this is another example I'm trying to connect with your export requirements. If the products have prove profitable in Thailand, Textra will expand its business to the other major automotive manufacturing countries in the region. So this was their beginning. Following 3 successive profitable quarters, Textra decides to pursue sales of the products in Indonesia, Malaysia, Vietnam, and the Philippines. It applies to register its name as a trademark in Thailand with a plan to register the same mark in the other 4 countries, claiming priority from the Thailand application. However, Textra discovers that the trademark has already been registered by Myers Manufacturing Limited. So upon further investigation, Textra was very surprised to learn that Myers has manufactured sensors of inferior quality and sold these for a reduced price under Textra's trademark. Okay, it turns out that the CM has been selling faulty Textra sensors that it manufactured to Myers, despite the contract between Textra and CM specifying that all faulty sensors were to be destroyed. Now, the problems are compounded when Textra receives a letter of demand from Myers alleging trademark infringement. See, first and foremost, they go ahead and use their name wrongly and sell the products. Second thing is, they in turn send a letter of demand alleging trademark infringement. Now, Textra seeks consultation from a local lawyer, discovers that Textra trademark was legitimately registered in Thailand by Myers, as Mars was the first registrant of the mark in the country. As a result, Textra cannot claim the ownership of the trademark against Mars in Thailand. Okay, outcome. Faced with the threat of lawsuits for trademark infringement by Mars, Textra feels forced to negotiate with Mars to buy back the Textra trademark from the latter at a substantial price. So it was a costly deal. They had to do this because otherwise, they will have to basically be considered as an infringer. So instead of that, out of court settlements, they bought this trademark. So IP lessons learned, EU SMEs should conduct due diligence in their local partners before working with them, should register their trademarks in the Southeast Asian countries of interest before or as soon as they enter the respective countries. So they should not delay the minute they have that idea, they should be approaching that. Trademark searches are very important to determine if a trademark has been already registered in the country by other parties and shall be done before entering the market. So this is what I was trying to tell you here. Okay, so what I'm trying to do is, I think those are the case studies which I wanted to tell you how important it is for you to utilize the international systems and go ahead and benefit out of the international systems, particularly when you're entering into when you're trying to export or entering into international trading. That is where the entire thing happens. So I'll just close this session by quickly telling you that when it comes to Madrid top applicants, that is basically, yeah.
Excuse me, ma'am. It's a very nice and informative session. Can you please share a few more case studies with us?
I don't, okay, I can just tell it to you
the
orally.
Participants are asked.
Okay, I can tell
maybe
you orally.
Your personal experience also can be shared.
Yes, I will do that. I'll definitely do that. So what I'll do is I'll just show you these slides, and then I'll share you a few cases where I have also personally dealt. I've handled it for
yes. You can extend for 10 more minutes. That's okay.
Okay, fine. I'll do that.
Thank you.
So look at the top applications when it comes to Madrid. So Madrid is an international design application which you can file. So these are some of the companies. This is a 2010. It says Midas Care Pharmaceutical. They are the ones who have utilized it. Okay, so then you have Biotech Vision Care Private Limited, Infrastructure. So these are the top applicants who've gone ahead and utilized the Madrid Protocol for filing their, this is basically for trademarks. So they have gone ahead and filed trademarks in these many countries. You can see Serum Institute of India is also done that. Okay, they have also used it. Okay, Patanjali is also used it. So these are some of the top companies who have actually tried to benefit out of the international systems we have. Hague top applicants is Preeti Kitchen Appliances from India. They have also well utilized this international application systems. There were around 15 million patents which were enforced globally in 2019. I couldn't get the 2020 data, which said PCT, the VIPU authorities are still collating. When I say 15 million patents were enforced globally, which means at that point of time in 2019, they were active. Okay, active across 15 million patents, granted patents. Out of that, you can see trademarks are 58.2 million, utility models 5.6 million, and industrial designs 4.1 million. Okay, so this is pertaining to that. Unfortunately, in 2019, patent filings decreased by 3% for various reasons, and I think one is trying to still analyze the reasons, maybe because of the pandemic. Maybe 2020, if we analyze, we will understand that. However, the trademark and industrial design activity grew in that period. It went up by 5.9% and 1.3% respectively, so which is definitely a good sign. And China is still leading in patent filing and trademark filing too. So despite substantial decrease in filings, as I just mentioned, China is leading for 1.4 million, followed by US, Japan, Republic of Korea, EPO, Germany, India is also doing fairly well. Okay, so this is what it is. A patent application for the top 10 offices in 2019. So it's glad that India is also coming up. We are trying to catch up, probably because of the various ways this kind of awareness programs are being created. Okay, so I think I would just show another one slide. The countries, which countries specialize in which technologies here? So computer technology, China, it was leading. Okay. Then again, you can see in digital communication, it was third. In electrical machinery, it was second. Japan is first in electrical machinery. This is based on the patents they have filed. Okay. Republic of Korea also is doing well. When it comes to measurement related things, China stood third, but yeah, I couldn't get the data for who stood first. And transport, again, it is Germany because of the number of motor manufacturing companies there. Okay, so this is how it's being spread across the globe. And China is still leading. It's way ahead than US and then Europe. And let's see in India, what is the condition here? So in India, the PCT top applicants, okay, is IIT collectively. It's just not one IIT. Then you have TVS Motor Company Limited. In 2020, IIT collectively 78, TVS Motor 51. Then you have CSIR Labs 46, Tata Consultancy 35, UPL Limited 30, Mahindra and Mahindra 13, Indian Institute of Science 18. Okay, these are the ones who have actually approached the PCT authorities to file for patent applications targeting the international market. All right. Okay. So since you wanted more case studies, before I take up the Q&A, I will give you some more examples here, which I have personally handled. So I'm not going to name the companies here, but I'll tell you what kind of issues they had to face. So there was one company, a local company here from Bangalore. Let me call them as ABC here. Now this company had interesting inventions on bearings. Okay, the motor bearings. So these people were into that market for quite some time. I think they have been doing well for 3 years, I would say, in the market. And they're quite successful. They also had an interesting trademark, and this trademark of a particular company called XYZ. And this company could not identify that there was some local manufacturer using their brand name and then selling the products. But of course, the company's name was, the name of this company was different, but they've named the product as XYZ. Now that is a difference here. I will tell you that in a while. So 3 years, it was quite good. So they actually made very good profit. Quality also was good. Because the quality was also good, a lot of people who were coming back and buying these things from him, these products from him. So he had a website. Website also contained various designs of these products, put up very well, and with the appropriate trade names. Now this company, in the 4th year, they go ahead and participate in a European market exhibition. Okay, it's basically to expand the scope of their business. So till then, everything was fine. So when they went to this exhibition in one of the European countries, the original company, XYZ, okay, so they stumbled upon this product and they were surprised to see that it was their own designs. And of course, they didn't do anything there and they kept quiet, and they came back, that company, and then they did this research. They took the complete details of this local company. This is an MNC, by the way. Okay, so that XYZ is an MNC. So they went ahead, did their homework, did everything. And as soon as, these people came back, the exhibition was over. After a couple of days, they receive a notice from this MNC. What is a notice stating that these are our products? You have copied our trademark, the name which they use for their products. They listed 4 trademarks. They looked into their website. You said the contents of the website also are copied. Okay. And the designs also are copied. So a notice was sent. Now, would this be considered an infringement? So infringement was pertaining to the design and infringement was pertaining to the trademark. Now they approached me, and then when I did my analysis, I realized that designs, of course, is something which we could overcome. There wasn't a problem there. Because some of the designs were getting expired, some of the designs were already expired, and there was also a possibility of these people modifying the design, but it was they didn't have a patent, so it was only focused on the industrial designs. Considering that, but what actually the local company did infringe was on the website contents. The contents were, I would say, 98% the same. So they had pulled up the same description of that particular product and placed it the way exactly the MNC had done, and the trademarks. So I was for sure that this particular company will sue them. Then I had to take a justification, right? I have to defend my client here. So I went ahead and defended my client under the concept of claiming innocence, stating that I was not aware that a company like this existed and they were using the same thing. Whether it really flied or not is a different question. But yes, that is a defense which I had to take for my client, and try to convince his company, stating that I think probably what he will do is he will stop using your trademark because he was not aware of it. And immediately I advised my client to change the website content. So everything was smooth, everything was changed. The trademarks were changed. In the trademark, this local client was very smart. He just tried, what he did was, how did he use this international MNC company's trademark? By just changing the prefixes and suffixes, right? So that way, it is still considered to be an infringement. So I advised him to make all these changes. And of course, continue to sell his products because, as I told you, with regard to the industrial design, he still was fine, but then he couldn't use that trademarks. So everything was modified. We reported to this MNC stating that so-and-so thing has happened, and, they should not take it forward and file for any infringement suit because it was unknowingly used. And fortunately, this MNC didn't come back. And after we gave them a declaration that everything was changed, they agreed to it and kept quiet. Okay, so but one needs to be, that's why I said one needs to be very careful when you are entering into the international market. And what first and foremost, what this local company did was incorrect. Okay. Copying something like that is incorrect. On top of it, he had the guts to go and participate in the international market, which I really appreciate. But then, followed by that particular notice. So that is another thing which one needs to be really, really careful as to what you're doing. Another interesting case, before I end up, I don't think there are a lot of cases to discuss, but I'll end up with this. I'll tell you why this is interesting. So again, one of my clients, he went ahead and exported some products to a company in US. He did everything after, he exported the first, the first round of business transaction was probably the amount of orders what he received in the first, under the first time was, say, some 10,000 units of a particular product. So the client was very happy. He goes ahead and sends it, and he promptly gets the money. And he doesn't think that something is wrong. Second time, again, there was a higher order placed by this US company. And this higher order was for around 25,000 units. And he was really excited. And that order was also placed. He went ahead and supplied. So after that, he received his money. no problems. Third time, this company placed an order of 100,000 units. And this client, trusting that, okay, although it's a big order, trusting that, okay, first 2 times I received the money, trusting that he would be receiving the money, manufactured and delivered it. After delivering, he waited and waited for several months, but there was nobody from that side whom he could actually talk to, because there was nobody responding, and he didn't receive his money. And that is when he approached us, finding out what can be done, and that amount ran into lakhs. For a small company, that was really big. Okay, several lakhs. First thing we tried to understand is whether he had some kind of an agreement in place. Unfortunately, he didn't have any agreement in place. In that excitement of receiving the orders, and then in the excitement of that, first and second time, it really worked. He received the entire money. He didn't even take any advance, right? So he didn't take any advance. He didn't have any legal document. And locally, we tried to see if there was any company like that existing there. That company like that didn't exist. He didn't do his due diligence. So even filing a local complaint there in one of the countries in US would not work, because it was some kind of a shell company where it was impossible to trace where it all went. They didn't know where all the products went. It is also a lot of expenses, which would go if you try to analyze where each product went, which part of US it was sent, or which other country it was exported to. So it was impossible to trace. And even his account, from wherever he got the money, even that he tried to trace, but nothing happened. So that is why it is important that when we try to enter into international market, have appropriate agreements in place with the people, do your due diligence, understand who that local vendor is, what is their whereabouts, and whether it is a shell company you're handling it, or whether it is a company actually exists. There's nothing wrong, and seeking professional help in the beginning itself, rather than losing money and then seeking professional help, which is like impossible to really work on that. So with this note, thank you very much for your kind attention. So I think it's open for Q&A.
Yes, thank you so much, ma'am. There are a few questions posted. So they've asked, how do we protect our traditional knowledge? How do we protect our traditional knowledge?
Okay, when you say how do we protect our traditional knowledge, when you're talking about international regime or locally, please understand that one individual cannot protect traditional knowledge. You can't own it, right? Because it is known everywhere across our country. So we all know that it is a traditional knowledge. So how do we protect it? One, probably you'll have to go ahead and publish some kind of an article, or a newspaper article, or a journal publication, or something like that in an appropriate form, so that people know that this kind of a traditional knowledge exists. We have another thing called a Traditional Knowledge Digital Library. All of you can access that, TKDL, which is a fantastic initiative by the Indian Patent Office with the help of CSIR. So your entire traditional knowledge is listed there. Now, in case you think anything is missing out there, just tell them. They will go ahead and upload it. This way, if there is anybody trying to exploit your traditional knowledge, okay, in any country without the knowledge of people who are actually practicing it, the mandate is that every patent office will have to review this TKDL database. The minute they review this TKDL database, if this traditional knowledge is listed in that, they cannot grant a patent, because it will be treated as the traditional knowledge from India. Okay, so that is one of the ways to protect our traditional knowledge. But you, as an individual, I will give you another example here if we have time. Say, this drug for this fish medicine for asthma, which is provided in Hyderabad. Now, this is, of course, maybe the traditional knowledge of that particular family, nobody actually knows what exactly gets into this fish medicine. One reason is these people do not disclose it. They don't give that fish medicine into your hand. They directly put that medicine into the fish and put it into your mouth, right? So you don't know how it is. So what are these people trying to do? They're trying to protect the traditional knowledge as a trade secret. They're not disclosing it to anybody. It's just passing on from family to generations. That is how they realize that they protect their traditional knowledge. Unfortunately, traditional knowledge cannot be protected under the patents, but of course, you can also protect it under the copyright law. So you write down somewhere, you have a right over that copyright, and you can, anybody can use that traditional knowledge. So these are some of the ways available to you.
There's also one more question, ma'am. What are the emerging issues in IPR with specific reference to India?
Emerging issues in IPR. Okay. One is pertaining to the domain expertise. You can see that we have various new domains coming up, right? Pertaining to the robotic sciences. Now, when it comes to robotic sciences, I think this is a challenge not only in India, across the globe. One tries to understand it. Or the 3D printing technology. Now, who's going to own what? Once if something is actually done, for example, by a robot, you as a creator of robot, are you owning it? Or the robot who, based on whatever feedback or inputs is gone inside, is the robot calculating themselves and coming with an invention? Is the robot owning something? So these are some of the interesting things which are coming up now, which not only in India but globally one needs to think. Enforcement is another aspect, particularly in India. I would say enforcement, and not everybody is pro. Pro about IP. Not everybody is aware about the complete rights about IP. And they also don't realize that infringing upon somebody else's IP is incorrect. Or, they don't realize that one needs to go and protect their IP appropriately. So that is where all this awareness focus really helps. And because of that, the enforcement, I think even our judiciary, or even when I say enforcement with regard to the police departments, for instance, not everybody is aware. If you go to the police departments here of a rural area and tell them that, okay, this is my trademark and this person is copying, so you need to take action on them because you have penal provisions for a trademark infringement, they don't understand that because they're not trained on it. We as an advocate are facing problem to go and convince them. Places like Bangalore itself, not all police stations are aware of it. When once a while, I go to the police commissioner's office to train all the sub-inspectors of various police stations to let them understand how one needs to attend to such clients when it is an IP infringement. You tell them any cases on hardcore murder cases, of course, they know how to handle. But they say there is an infringement on IP. Unfortunately, they don't know. So there is a lot of work happening in that. Both the government, state, and the central government are trying hard to ensure that these people understand what and respect the IP of every company. I think that is one of the major issues, and they're working towards it. Maybe over a period of time, they will all be well versed with it.
Thank you, ma'am. One last question. They have also posted that what cannot be patented in our country?
Okay.
What cannot be patented?
So what cannot be patented? A discovery. I will not tell you the entire list. So whoever is interested, probably you should review Section 3 of the Indian Patent Act, which clearly tells you what are the inventions that are not patentable. So I'll just give you a few instances. Somebody asked me the question of traditional knowledge. So traditional knowledge cannot be patented. Discoveries as opposed to inventions. We have really distinguished between discovery and inventions in our country, and discoveries are something which cannot be patented. Any invention which is, against the interest of the country, or which is going to harm the environment. So those are the inventions which are not patentable. Computer program per se, software per se is not patentable. Software associated with hardware can be patented. So these are some of the examples. You have a list of some 10 or 12 non-patentable inventions. So for details, please refer to Section 3. And of course, inventions related to atomic energy. So that is Section 4, 3 and 4 of the Indian Patent Act. Somebody has raised hand. Okay. Hello.
It's Gaurav Goel, sir. I'll just allow them to talk.
Please,
Maybe they have
please.
a query.
Yeah, please.
Goel, sir,
Yeah,
you can
hello.
unmute. Hello,
Yeah.
sir.
Can you hear me, ma'am?
Yes,
Yes, sir,
yes.
we can hear you.
Ma'am, I just want to ask that the case which you discussed, which was related to the exporter.
Mm.
So, ma'am, in that case, if that exporter would have actually taken that letter of credit in agreement with the party to whom he or she exported, was there any possibility in that case that he could have got that protection or the money from the guarantor who has taken the
No, he
guarantee?
didn't take that. There was no guarantee which he actually sought. The reason was because this company smartly started taking only smaller quantity in the beginning. Okay. So the
Okay.
first quantity, of course, they took some advance. And that kind of, order placed was by a shell company. So once it is a shell company and you have not really analyzed whether it's a shell company or a company which which is in existence and then try to send it. So shell companies, it is just for the sake of it, it's been created. So you really can't trace who's done what.
Ma'am, actually, what I'm trying to ask is that if this exporter would have taken the letter of credit in advance,
No, they
then
didn't. Third time, they didn't. For a
third
larger
time they did.
quantity, they didn't. Because that was a trust factor created.
Okay.
They
And
didn't.
ma'am, one more thing I want to know, ma'am, like the thing which you mentioned regarding this medicine which is given through the fish in Hyderabad. So, ma'am, as they are actually keeping their secret by not telling it to anyone, this is the only way they are adopting. So, in case because of any complication, someone is going to sue them in court, then can the court make them to actually reveal the composition of
Yes.
the medicine?
Yes, they can.
Okay.
The court can.
Okay. Thank you, ma'am. Thanks a lot.
You're welcome.
Thank you so much, ma'am. Thank you so much.
You're most welcome. So that's the end of the questions, I guess.
Yes. Thank you, ma'am. Thank you for enriching us with a rich source of knowledge and sharing your personal experience. Thank you once again. I now request Professor Anita Kurian to propose vote of thanks for today's session. Over to you, ma'am.
Good evening. It gives me immense pleasure to propose a vote of thanks for this technical session. I would like to thank our resource person, Ms. Brinda K. Verma, for her insightful presentation. Thank you so much, ma'am. You took a lot of time to actually explain case studies after case studies because we had a lot of questions to ask about it. So thank you so much for staying back and thank you for your patience. Thank you, ma'am. Let me also thank the participants for their active participations and definitely asking a lot of questions to understand this subject as much as possible. Participants, please note that the feedback link will be posted only during the vote of thanks of the valedictory session. Okay, so we're just going to start with the valedictory program right now. Thank you so much, ma'am, for joining our session once again.
Thank you all. Thank you for this opportunity. I hope it was useful to every participant here. Thank you. See you all again.
Thank you, ma'am. So let's begin our valedictory program. Good evening, dignitaries, participants, and colleagues. It gives me great pleasure to welcome you to the valedictory program of the 5-day virtual FDP on changing dimensions of IPR in India and intellectual deliberation. Now, let me request Professor Ashwini HM to introduce our chief guest.
Ashwini ma'am, please unmute your. Yeah.
Yes, sir. Thank you so much, Professor Anita. It gives me immense pleasure to introduce our chief guest to the session, H. Hemant Kumar, sir. He is currently serving as an executive secretary in Karnataka State Council for Science and Technology. He joined the council in 1985 as project engineer and has postgraduate degree in engineering from Bangalore University. His areas of specialization is geospatial technology, spatial data infrastructure, alternate building technologies, watersheds, and minor irrigation tanks and e-governance. He is currently investigating Karnataka Natural Data Management System programs, state spatial data infrastructure projects, and many more. Sir, till date, has investigated more than 30 projects. He has written various research papers on natural resource management, non-organic solid waste, web geoportal, and uses of GIS and RS for informed decision making. Sir is a member of various expert technical committees. To name few, is the Committee of Department of Science and Technology, Government of India, National Biodiversity Authority, Department of Biotechnology, and many more. Sir has also organized various national and workshops and events in international forum as well. Sir has received Geospatial Excellence Award in the year 2014 by Indian Geospatial Forum for Karnataka State Spatial Data Infrastructure Project. His current interests are focuses on catalyzing science technology innovation, ecosystem for assessing, implementation, and delivering appropriate solution to state-specific issues and challenges. A warm welcome to you, sir. I now request Mr. Hemant Kumar H. to address our August gathering. We request the participants to please stay online. Sir will be in a minute.
Participants, just a small information. It will take some 2 minutes for him to join. So we request Divya ma'am to start with the report.
Divya ma'am, could you please give us the report of the FDP?
Good evening, all of you. I stand before you to give the report of 5-day virtual FDP on changing dimensions of IPR in India and intellectual deliberation. To provide an awareness about the role and significance of IPR in the present scenario, the IQAC of Jain College, affiliated to Bengaluru City University, in collaboration with KSCST, organized 5-day virtual FDP on changing dimensions of IPR in India and intellectual deliberation, with the main objective of FDP to sensitize the participants towards the changing dynamics of IPR in India, to enable the participants to develop a comprehensive understanding of the invisible demarcation of different IPRs and their interconnectivity, to facilitate the target group to appreciate the legal framework of IPR in India, and to provide them with a practical insight into various compliance procedures in India and global perspectives. Outcomes of the FDP: to equip the target group with an appreciable foundation of IPR in India and to enable them to utilize their understanding in various academic and research endeavors. We had a very overwhelming response that we received as against this virtual FDP by having 500 odd registrations that we received from across India, Sri Lanka, Bangladesh, Nagaland. We had about 150 external participants and 40 internal participants of our own college, including faculty members, research scholars, and industry professionals of various organizations across the country who participated in this virtual FDP. Colleges in and around Bangalore, Kerala, Maharashtra, Jamshedpur, Coimbatore, Tumkur University, Mysore University, and BITS Pilani were major stakeholders here. The FDP sessions were very interesting throughout. The program was enriching and intellectually stimulating for all the participating faculty members. Eminent resource persons at the event of this virtual FDP were, for the first session, we had Professor Girish, Assistant Professor from the Department of Commerce and Management, Government First Grade College, Frasertown, Bangalore, who introduced the audience to the topic overview of IPR in India. The presentation that was covered by him was very, very informative. It had a lot of useful materials. The day 2, that is, we had Mr. J. Suresh, who is an advocate, patent and trademarks agent, and as well the founder of J. Suresh and Associates, who was the speaker of the second day. In his session, he showered light on the legal framework of IPRs in India with rich experience by sharing all the case laws throughout his journey in his career. On day 3, we had Mr. Vivekanand Sagar, consultant and IPR attorney, Patent Information Center, KSCST, ISC Campus, Bangalore, who presented on the topic Perspectives of Copyrights Act towards Academic Integrity, Plagiarism, which led emphasis on academic writing and publications. Day 4, which was yesterday, we had Mr. Nagarjun, Project Associate, KCST, IESC Campus, Bangalore, who spoke on patent in academic research, commercialization of patent. He explained in detail the process of filing for patent. Today, which is the 5th day, having come to an end of this 5-day virtual FDP, we had Ms. Brunda as a resource person, Brunda K. Verma, who is the managing partner of ACOM Legal Advocates and IPR Consultants. She laid emphasis on the broader topic of global perspectives of IPR, its challenges and opportunities. We are very happy to say that this virtual FDP has been very successful in equipping the target audience with a comprehensive understanding of IPR in India. Thank you. Over to Ashwini.
Thank you so much, Professor Divya. Our chief guest has joined our session. I welcome Mr. Hemant Kumar H to the session, and over to you, sir. I would request you now to take over the session and address our August gathering.
Okay, sir. Unmute Nagarjun, sir.
Sir, is it audible, sir?
Yes, sir, you're audible, sir.
What about the video? Video is not coming?
No, we are not able to see your video, only audio.
Okay. I think you have to enable me to switch on the video, sir.
I had done that one. Just give me a second, sir.
Please, please, please. Take time. Yeah.
Yes, sir. Yes, sir. No worries. Okay. Okay. Okay.
Nagarjun, sir. Yeah.
Yeah, hello, sir. Just a minute. Sir is there. 1 second.
Yeah. Yes, please.
That's it. I think so.
So yes, sir.
Yeah, sorry, it's a bit delayed because I couldn't connect it properly. Yeah, please go.
Welcome, sir. Yes, yes.
So,
Ashwini, ma'am.
Yeah, can I go on now?
Yes, sir. Yes, sir. You can start, sir.
Okay. Good evening. It's really a pleasure that Jain College is making this possible for a week-long program. I'd just like to introduce myself and the council here. I've been working in council since '85. I started as an engineer and now the executive secretary of the council. The major the goal of the council is to see that promoting scientific temperament is the first and the primary goal, and that's the goal of most of the councils. And for us in state council, since it's established by the Faculty of Indian Institute of Science, we look into the applications of science and technology as our fundamental objective here. So we work with the IISc faculty and also all the R&D institutions, not just in Karnataka, entire India, to take forward whichever the product or services technology which is appropriate and right for the people. So that's a challenging task, and also it requires complete dedication to the technology that we believe in, that will work in the field, and we need to make it happen. So to start with this, council has many projects and programs to its credit, and right now we have starting with JS and remote sensing for informed decision making. This is one of our core projects wherein we use technologies for preparing action plan. That is, all the government programs are now depending on the JS and remote sensing capability that we have, not just with Karnataka State Council, it's also our sister concern, State Remote Sensing Center. So the state, now we can say that we are moving towards geospatial governance. So there are very few states in Karnataka, I mean in India, that is using technology. I mean, you must have noticed by this time that all the states have adopted digital platform, but you must know that geospatial technology is still emerging, but our council and our state actually is quite a large way ahead from other state council in terms of its usage, and especially in government. Apart from that, we have the water education, so on and so forth. In water, I think we did a pioneer work in bringing out the rainwater harvesting policy, and also we are now just not just serving the city of Bangalore. We are moving to other tier 2, tier 3 cities, so that the benefit of RWH, that's rainwater harvesting policy and systems, goes to all the small towns and cities. That's our future activities. And the education, you may be aware that since '77 we are funding final year engineering projects. Basically, this is quite a sensational things among the engineering students. This year, we funded close to 1,200 projects, and out of which 100 plus are going to be shortlisted for awards. And further on, this year specifically, we have tied up with other agencies, including KTech, to conduct mentorship program and startup programs for this best projects. So that this is a 3-day mentoring and startup program. So the council also in this year, the best projects are going to get the real estate in the terms of you get the place to work in, free space, and also you'll get the hardware components, and you also get the mentoring from the experts, so that if any student has a good idea, which is already been demonstrated and showcased in our SPP program, it will be taken to the next step of funding. So this, this one of the good thing happened this year. That is, KTech is coming forward to help us in taking the good projects from engineering institutions to leading to product and services. Basically, we look into commercialization of projects. And that should be the goal of not just the council and all the institutions across India. Because somewhere down the line, I believe that institutions is not just for teaching. They should also mentor the students and people, faculty in terms of they have an idea. Not, I mean, just we talked about IPR for 7 days, and if I don't pursue this thing with passion and vigor in my own institution, it's difficult for me to convince others. So the first thing we do is try to see that the best projects taken up for commercialization. So whatever that could be done from council side, we do it. So apart from that, recently we have added up quite a few things. That is Center of Excellence, Cybersecurity is one among them, which is in the umbrella of KCST. And apart from that, we have the another Center of Excellence, Aerospace and Defense. And they do conduct a large number of training programs for the students and faculty. And one of the core strength of the centers is mentorship and startups. So it is mostly for students and faculty, not just that, any innovator or inventor can come here. We do have a few more things like alternate building technologies and rural energy, specifically bioenergy. So we are working with many government agencies, especially Karnataka Bioenergy Board for bioenergy development. So working on right now biodiesel and ethanol blending for petrol. And the policy also states that the government of India should, over a period of time, not just depends on the fossil fuels, we should look for alternate fuels which is going to be long lasting. And that way you can also cut down your import cost and also generate employment within the country, within the state. In housing sector also we made quite a bit of difference to the way we look at the housing sector itself. One of the core technologies, stabilized soil blocks, which is there. Since we started working in 80s, now we could see that more than 20,000 houses have come up using this technology. Apart from that, we have for the roofing elements, more than 14, 15 different designs we have that could be chosen. So apart from savings, they look different and mostly energy efficient buildings. So this is the way we are working on. And another thing that we added up in the last decade is the patent. I think Government of India came up in a big way of promoting patents, IPR in India since 2010 onwards. Before that also we had. So we look into following things. That is, our IPR cell is mainly created to support the students, faculties, and innovators, and whosoever is interested in filing patents or they need guidance in doing patents, things like that. And I think anyone can approach us, that is on patenting, copyright, trademarks, design, geography, indications, brand varieties, and so on and so forth. So we do conduct a large number of training programs, at least 5-6 programs in each month we do conduct. It could be 1 day, 2 day, 3 day, 5 day, depending on the need and depending on the participants' background knowledge about IPR. So this is going on for quite some time, and recently under this program, we are giving fellowship to women scientists this year. We are giving about 120 women scientists across India, from Delhi, then Bangalore, then Bombay, and I think Kharagpur is another town. In each place, we're going to have 30 women scientists who will be working on IPR alone. So these women scientists are, I mean, we have received a tremendous number of applications this year, about close to 4,000. So we're going to be shortlisted, and each of them who've been selected for this fellowship will be placed in the IPR farms, not just in Bangalore, the entire South India from our center. So this is one of the good activities which we are doing TIFACT actually thrusted this work on us, believing that Karnataka, especially Bangalore, is the hub of IP as well also innovation. I think the students who get selected for this program will really enjoy their stay for 1 year. I hope that many of your students might have also applied. Apart from that, we have this TIS center, that is Technology Innovation Support Center, which is actually an effort from SIPAM, that is Cell for IPR Promotion and Management. This is a VIPU based thing, so it will provide you online access to patent and non-patent resources. Hopefully, all our cells will get the benefit of this center, wherein they can extensively research for patent related activities. So apart from that, fortunately, we have a good number of collaborations with the institutions like the Department of Science and Technology, Government of India. They support through funding and expertise, and SIPAM Cell for Intellectual Property Rights Promotion Management. Then we have a working relations with KCTU, VTPC, National Art School of India, KBITS, and NRDC, and so on and so forth. And recently, may be aware that we invited applications for the awards. We are giving awards this month in the category of students, faculty, institution, and startups. We have shortlisted close to 30 and they will be awarded this month on 24th. So this is one activity which we are taking up to promote IPR in a big way. And see, this IPR movement and building ecosystem was initially slightly slow, but nowadays it's picked up its pace and it's doing well. I think some of the colleges have very high hopes that they're asking the faculty to file at least one patent each year. I don't know how far that's feasible, but that at least what I see is that the interest and the enthusiasm they take up in promoting IPR and filing patents is really wonderful. I don't see that 2 years back. So this year itself, we filed more than 80 patents have been filed, and with the assistance of KCSTI patent cell. And we also do a lot of copyrights and GA also to some extent we are doing with the students coming from different law colleges. So I think giant colleges adding to our IPR cell gives us and gives the college further wings to promote IPR in a big way among students and faculty. And hopefully our collaboration and the working relationship will prosper in a big way in future. And Jain also sets a target for its faculty and students in filing patents. And this way, the organizing this kind of week-long program will certainly result in some tangible deliverables. So whenever we collaborate, whenever we work with, we set up a goal and a target, and that is for all our projects. And we try to stick to our targets, also the deliverables. And we do that in the best interest of promoting IPR, and also seeing that both economy and both employment also flourish because of our innovation and because of these activities. I wish the participants participate in the week-long program all the success, and in case they have any issues or any requirements have in IPR related work, they can definitely contact our IPR cell for more information. And wish you good luck, and thank you. Thanks for giving us time and engaging with cases. Thanks once again.
Thank you so much, sir. I'm sure that the connection between the organization and the industry is going to see newer heights. It is a matter of great pleasure and honor for me to welcome the backbone of Jain College, Vasavi campus, Dr. Naveen Kumar, CM. Sir holds a doctorate degree in economics from Bangalore University, LLB degree from Karnataka State Law University, MPhil from SV University. He is also authored many books for undergraduate studies, to name few: Managerial Economics, Business Economics, GST, Personality Development, and more. Sir has published various articles and participated in various national and international conferences. Under his leadership, Rotaract Club of Jain College was awarded the Presidential Citation Award for the year 2014-15. This award being the highest recognition award to Rotaract Club. Sir has worked in various capacities, and one being the Vice Principal of Bangalore University Division of Jain College, Jayanagar Campus, and has been serving as the Principal of Jain College, Vasvi Campus since 2017. I now request Dr. Naveen Kumar CM to give away the closing remarks of the 5-day workshop.
Good evening. Is my voice audible?
Yes, sir.
Thank you, Ashwini Madam, for that wonderful introduction of mine. First of all, let me extend our gratitude to Karnataka State Council for Science and Technology. Amen, sir, thank you so much for collaborating with Jain groups of institution in organizing this 5-day virtual workshop on a very apt topic on intellectual property rights. So thank you so much, sir. I hope this collaboration continues even in our future endeavors also. Yes, this 5 days workshop on intellectual property rights, I was just, listening to the report rendered by Divya Madam. And it was a clear evident that a person who is sitting, a layman sitting at FDP and listening to this intellectual property right, probably on 5th day, if not everything, the glimpse of intellectual property right would have been definitely been there. And in this regard, I think I need to take few names who spoke about property rights, who spoke about copyright, who spoke about patent. I think the first day was amazing. We found Professor Girish was speaking on the overview of intellectual property right. And second day, we found Suresh sir was giving the legal aspects of the intellectual property rights pertaining to patent, pertaining to the copyright. And the third day, we were listening to Vivek, who is actually the main person who gave us the connectivity to this Karnataka State Council for Science and Technology. Thank you, Vivek, for all the support that you have extended to us. And he was talking about the academic integration. And Nagarjun was speaking about the commercialization aspect of intellectual property rights. And today, Brinda Madam was basically talking about the challenges and opportunities, what you can have as far as the copyright, as far as patents, as far as overall, in a nutshell, I can call it as intellectual property rights. So it's an amazing job done. So my wholehearted congratulations and extend my heartfelt thanks to the entire team of IQSC, headed by Divya Madam, Sarvanan, Shruti, Hakila, and Ashwini Madam. I think a special name has to be definitely mentioned here. So Divya Madam, thank you so much for all the effort that you have put in. And Sarvanan, I think you also deserves an appreciation to be extended. And Shruti and Ashwini Madam, even Akila, the entire core team. It is not easy for to have a webinar at this magnitude to make it so smooth, and it was wonderfully organized, and it was wonderfully smooth. The functioning was so smooth. I think the credit deserves to the entire organization. So, of course, to take, I should definitely extend our sincere thanks to our honorable chairman, sir, Dr. Chandraj Roychan, sir, who is always there for all the programs what we initiate. And in fact, today Ishwaran sir wanted to be a part of this particular gathering, but because of his busy schedule on NAC, So he just said, please wish on my behalf. So I am wishing on Dr. Ishwaran sir's behalf for the entire organizing team for your wonderful effort. I'm sure this effort will be more rigorous in the coming days to go. So it's really, the numbers of registration, which was to the extent of 500, it's not so easy. Within a span of 1 week or within a span of 6 days, it's not so. So that shows the collaboration what you have with the academic circle as such, and that has made. I'm sure all the participants, even at the valedictory, I'm seeing 122 participants are there. So yes, the participants who are there right from day one, I'm sure you had an amazing time as far as knowledge gathering is concerned, and I'm sure Jain College will always step in to ensure that FDPs like this, seminars like this, and a workshop like this will be a continuous process. So I should thank all the participants for your active participation for 5 days. I think you had a nice time with all the resource person, and the credit should be given to all the people who really made this FDP success. I'm sorry if I'm not mentioning few names. I think the entire faculty, members of Jain College Vasavi campus deserves appreciation. And of course, I should also thank all the HODs of Commerce Management and Language Department who have also extended their support to make this event a grand success. So amazing event, keep it up, all the very best. And thank you so much, IQSC core team. It was amazing work that you people have shown, and sky is the limit. So all the very best. Thank you so much.
Thank you so much for your kind words, sir. It's indeed a pleasure to have you as a backbone and as a beacon of light for all our endeavors. Thank you so much, sir, and looking forward for your support forever. I now request Professor Shobita to give away the vote of thanks.
Am I audible?
Yes, ma'am.
Okay. Good evening to one and all. On behalf of Jain College Vasavi campus, myself Shobita, deem it a great honor and privilege to propose vote of thanks to those who have directly and indirectly contributed to this webinar. I would like to express my gratitude to Chief Patron Dr. Chenraj Roychan, Chairman, Jain Group of Institution, for his constant support and encouragement. I extend my heartfelt thanks to Sri Ravindra Bhandari, Vice President, Jain Group of Institution, for his enthusiastic support. I extend my gratitude to Dr. Sundararajan, Pro-Chancellor, Jain Deemed to be University, for his guidance. I also would like to thank Dr. Ishwaran Iyer, Pro-Vice Chancellor, Jain Deemed to be University, for always being there as a source of inspiration. Special thanks to Mr. Hemant Kumar H, Executive Secretary and Chief Scientific Officer, KSCST, for this collaboration in organizing 5 days workshop. I would like to thank our beloved principal, Dr. Naveen Kumar CM, for providing moral support and guidance to make this webinar a successful. I also extend my gratitude to our resource persons who made this webinar a grand success. To be in particular, Professor Girishian, resource person for day 1, Mr. J. Suresh, resource person for day 2, Mr. B. Vivekanand, resource person for day 3, Mr. Nagaraj MG, resource person for day 4, and Ms. Brinda K. Verma, resource person for day 5, for enlightening us on various aspects of IPR. I also thank all the participants for their patience listening and active participation in the webinar throughout the sessions, all the 5 days. A special thanks to the organizing committee, teaching and non-teaching staff for their constant support and coordination. Thank you one and all. And the feedback link is shared. You can just fill the link.
Thank you very much, Professor Shobita. Thank you once again from the faculty of Jain College Vasavi campus and from all the participants and all the non-participant participatory group who has contributed to this 5 days virtual FTP. Thank you so much, participants. The feedback link has already been posted in the chat box. Kindly fill in your feedback to receive your e-certificates. Thank you once again. Have a great evening. Meet you all very soon. Thank you.
Naveen sir, thank you, sir. That's it.
Thank you.
Thank you, sir. Thank you, participants. Thank you.